I know I'm covering a lot today, but this is one that really bothers some people. What many people do when they start reading bills is they start reading the bill the same for every kind of problem. So if you see a postage charge that's out of whack, you look at it the same way as whether or not there were 3 or 4 or 5 or 6 lawyers working on something. This was created for one of our clients who requested it, and here's the issue. If you look at this axis here, the fee reduction per task goes up. So eliminating time increments of 0.25, that really creates a lot of savings. Eliminating clerical tasks by professionals creates a lot of savings. How hard is it to administer the rule? Well, if you move in this direction, you need more and more attention, more and more physical monitoring, and more work to administer that billing rule. So essentially, if you're looking at the graph somewhere around here, this is the area where you can really start to see the most changes, and of course this one might be worth it for you, if you put the time and the effort in. Now, these percentage savings are not cumulative, they don't stack, but if you put them together, you start to see these types of savings created over time. Again, the fee reduction per task going up, the complexity of administration going in this direction. Okay, let me talk about something else. Despite the issues that we've discussed, many companies' billing guidelines are very hard to work with. And some of them are so long that they're very difficult to work with. They're just page upon page upon page. Others have billing guidelines that are short, which is great, except they're so vague, it's hard to know when there's a problem. My feeling, focus on reasonableness and effectiveness. Focus on the core elements that will give you the most bang for the buck. That's where I think people should be when they're talking about billing guidelines. The other is to focus on standards that create real efficiency, real tangible savings. Another element, transparency. It is actually surprising to me the way some firms resist billing clearly. And I have actually seen companies that are reluctant to make them bill clearly. What billing clearly means is you don't want 1 or 2 words in a time charge, work on matter, something like that. It's impossible for a client to really understand it. And that's really an unfair situation. The next is the standards should be such that if someone's reading the bill, they know when there's a problem, they know when there's not a problem, and benefit from industry best practices and cooperation. There are such great best practices out there for billing guidelines, for monitoring and monitoring workflows. It will save you a lot of time to get access to them. And we can help with that, and there are other places you can go as well. Here are a few conclusions that I want to just get out there on the table. One is, I think clarity is, and fairness in general, is something that all of us need to strive for. Clarity means you want billing guidelines that people agree upon. You want billing guidelines that get the most economic elements, and you want to make sure that those elements are really having an impact. And better communication by having clarity helps as well. Flexibility and fairness. Once the billing guidelines are set, you want to make sure they're fair, you want to make sure they're flexible, and I really believe that bringing law firms into the process of amending and creating the guidelines makes them better. And I'm not sure many other people do this kind of thing, but having spent a lot of my life in law firms, I think it's important. Efficiency. Remember that rate negotiation is just the beginning. And incidentally, the partner's rate is just the beginning. If we look at some of the studies that we have done, we have seen that there's actually more total cost in associate and paralegal time than there is in partner time. Concentrate on those lower rates for those other positions. That's where you'll see a lot more of what you need to see to determine how much you're really going to pay at the end. Utilization, extremely important. We talked about that one before too. Consistency. incredibly important in this scenario. I've seen so many companies that have billing guidelines that are not enforced, monitoring that no one has time for. These elements and these issues have to be addressed. They actually hurt law firms who try to be compliant and then find that no one's watching. That's not good for them either. So for everyone's sake, it's great to have great guidelines, reasonable workflows that help everyone do this quickly. In fact, we find that with the right workflows, that quick pay discounts actually work pretty well for companies, and that's good news for everyone. I want to thank everyone who's been on the call. We are ending about 5 minutes early. Do we have any questions here? Okay, I'm seeing one question, several questions. One is issue, I have seen significant charges for pure travel. Is that reasonable? It's not reasonable if there has been a clear prohibition against pure travel in the past. In other words, you need to have some clarity on your guidelines. Another person has said, I have been charged for work that does not appear to be complex or justified by the rate. That's a real issue. And I can tell you that if you have the right guidelines in place and the right monitoring protocols, that kind of thing will get caught. There are ways to do that. Okay, do we have any other questions? Someone else has been talking about staff training, which I believe we've all talked about a lot. Some of the disbursements on the bills appear to be firm overhead. Should we be paying those costs? And the answer is no. There are actually elements of some of the some ethical rules that can be applied in that situation as well. Finally, legal research seems to be performed on a repetitive basis. Here is something I really want people to think about on the call. If your company pays for legal research once, why should you pay for it again? You shouldn't. The reuse of the legal research and the knowledge and the familiarity with your company should be to your benefit. You shouldn't be paying for it over and over and over again. Another issue is paying for online subscriptions. There are many people who feel the following. When I first started to practice law, and some of you will know how old this makes me, we had no online subscriptions, we just had books. And would we ever have thought, under any circumstances, of charging our clients for our subscriptions to those books? And the answer is absolutely not. Those were the tools of the trade. Yet a lot of many law firms today think nothing of charging for online legal research subscriptions. They're basically, in my opinion, pushing a tool of the trade, their overhead, back and making their clients pay for it. I'm not saying that it is wrong to the point of being actionable or anything at that level, but it is certainly an issue. And good questions, and I do appreciate them. If anyone else has more questions, please be sure to send them through. For all of the rest of you, thank you so much for attending today. Talk to you later. Bye-bye.